Wow, hello and welcome. We are in for a wild ride. Peter's got the wine, Diamond Crystal Arts has got the cake. I need to warn you though, there will be moments where the wine could end up on the computer screen because there's a couple of claims in Katie Joy's motion to dismiss that I find to be laughable, and I'm really sorry, but to cut a really long story short, she's claiming the journalism defense. That's what she's doing. she's using the journalism defense. So so yes, we are in for a bit of a wild ride. That's why I said get the popcorn ready. So I just want to show you, first of all, we're going to work backwards. She's still lying. Yeah. So this is the Minnesota Judicial Branch, the court records online. So put in the case documents. So this is everything that's here. So we've got certificate of representation, proposed order or document, affidavit of attorney, memorandum, and motion to dismiss. Now, I've downloaded all of those. So we're going to start backwards because in the attorney's affidavit is Chrisley's claim that we can have a quick look over. I think we need to have a look at what is said before we go to the motion of dismiss and the memorandum. The memorandum, 16 pages. So as I said, we're in for a bit of a wild ride. So this is starting backwards, as I said. Look, you know what, Peter? I have not got past the line that she's a journalist. I think that's, in the first paragraph that she's a journalist, and then she goes on to say that she's quoted by many news agencies. I haven't got past that, so I've got no idea. So this shows that this is, Graham M. Martin is her lawyer, and that he is now on file as the attorney. All right. And interesting here, it's classed as personal injury. I find that to be really fascinating as well. So attorney for defendants, Graham Martin. So, all right. So then we go backwards. So this is, it looks like court is going to be on the 6th of December. So make sure you write down the 6th of December because this is the proposed order. So the proposed order says the above entitled matter came before the Honourable, they don't know, Judge of District Court on December 6, 2021 on defendant's motion to dismiss. Charlie C. Goki Esquire appeared on behalf of plaintiff, Graham N. Martin Esquire appeared on behalf of defendant. Based upon filing records proceedings, it is ordered the defendant's motion be dismissed if granted. Counts 1 to 4 of plaintiff's complaint are dismissed without prejudice. So this is what Katie Joy wants. So on the 6th of December, the motion of dismiss, the motion to dismiss is being heard. Okay? 6th of December. So we go back now and we go to Declaration of Graham M. Martin. This is 48 pages long. Now, interestingly, in here we're going to get the original Chrisley complaint. We're also going to get all the dirt on all the other stuff. He's pulled up court records and everything. All right. So they're playing a little bit. 7th. Oh, yes, it'll be the 7th for us. That's right. On the 7th day of Christmas. All right. So Graham N. Martin, duly sworn, states, I am attorney licensed to practice in the state of Minnesota and am the attorney on record for defendants Catherine Mansky Paulson and Without a Crystal Ball LLC in the above captioned matter. A true and correct copy of the plaintiff's complaint in this matter is attached as Exhibit 1. A true and correct copy of the docket in the case of United States of America versus Chrisley is attached as Exhibit 2. A true and correct copy of the docket in the case of Chrisley versus Waits is attached as Exhibit 3. A true and correct copy of the Cherokee County Police report filed by Lindsay Chrisley on the 16th of July is attached here too as Exhibit 4. So you can see where they're going with this, don't you? Further, your declarant saith not. What? Pursuant to Minnesota State, I declare under penalty of perjury that everything I have stated in this document is true and correct. Now, that's really interesting because I thought it was to my. I thought I know that I thought they would that it's normally said as in my knowledge, because to state that everything I have stated in this document is true and correct. What if he's been lied to? I'm just putting it out there. So this is the original Chrisley complaint. So Michael Todd Chrisley brings this complaint about Catherine Mansky Paulson, aka Katie Joy Paulson. All right, so he said and alleges as follows. For 2 years, Katie Joy Paulson has made a living by broadcasting defamatory falsehoods about Michael Todd Chrisley to her thousands of social media followers. She has repeated and embroidered malicious lies about Mr. Chrisley, star of USA's popular reality TV show Rufus Knows Best. Chrisley Knows Best. In order to drive web traffic to her various social media platforms. While her campaign of defamation has ranged over a variety of topics, Miss Paulson has played a key role in spreading and perpetrating a particular vicious fiction that Mr. Chrisley attempted to extort his own daughter, threatening to release a sex tape and nude photographs of her unless she agreed to perjure herself in a criminal investigation. This allegation is unequivocally false. Mr. Chrisley never made such a threat, nor, to Mr. Chrisley's knowledge, does such a tape exist. Miss Paulson, a self-described close friend, personal friend of Lindsay Chrisley, has nonetheless repeated it over and over. She has touted her friendship with Miss Chrisley, implying that she possesses inside knowledge of the incident in question. She has even fabricated an interview with an anonymous Chrisley Knows Best crew member, corroborating it. But Miss Paulson has known this improbable and incredibly damaging allegation to be false from the start. She has repeated it to curry favour with Lindsay Chrisley, whose friendship with Miss Paulson is among the few things distinguishing Miss Paulson's social media presence from her competitors, as well as to enrich herself at Chrisley's expense. Not content merely to repeat this falsehood, Miss Paulson has recently accused Mr. Chrisley of attempting to extort her as well. She has falsely claimed to her thousands of followers that Mr. Chrisley made threats against her and in doing so had committed the felony of extortion. All right, hands up if everybody remembers that happening. Put your hand up. Put your hand in the air. Yeah. Mr. Chrisley will not suffer further accusations of criminality and unconscionable behaviour towards his own daughter. Accordingly, Mr. Chrisley brings this suit. Michael Todd Chrisley is an individual of Nashville, Tennessee, located in Davison County. Catherine Mansky Paulson, a.k.a. Katie Joy Paulson, is a resident of Hanover, Minnesota, located in Wright County. Without a Crystal Ball LLC, WOACB, is a limited liability company incorporated in Minnesota under the auspices of which Ms. Paulson operates and monetizes her various social media outlets. On information and belief, Ms. Paulson is the sole member of WOACB and completely dominates its operations. Ms. Paulson and WOACB are alter egos of each other, or at the very least acted in concert in committing the torts described herein. I love that. Ms. Paulson and WOACB are alter egos. Alter egos. Michael Todd Chrisley is a real estate investor and the star of Network's reality TV Chrisley Knows Best. The program, now in its 9th season, follows Mr. Chrisley and his family, including his children. Lindsay Chrisley is Mr. Chrisley's eldest daughter. She played a recurring role on Chrisley Knows Best until its 5th season. At that point, the network declined to include her in the future seasons of the show. Lindsay Chrisley blamed her family, and particularly her father, for her ejection from the series. As a result, she became estranged from her family and lashed out at them in the media over the following years. On October 17, 2019, Lindsay Chrisley gave an interview on the talk show Dr. Phil. She recounted a meeting between her and her father at which Mr. Chrisley discussed criminal investigations into him and his family. In her account of the meeting, she denied having an affair with a state official involved in one of the investigations. She stated that Mr. Chrisley told her at the conclusion of the meeting that Chase Chrisley, her half-brother, had obtained a sex tape featuring her and a man other than her then husband for $5,000. She agreed when asked by Dr. Phil if she viewed this as a veiled threat against her. Lindsay Chrisley's account of the meeting is inaccurate. But even taken as true, Mr. Chrisley did not threaten to release this sex tape or naked photographs of his daughter or to coerce Lindsay Chrisley into lying to authorities. Mr. Chrisley did what any father would do in this extraordinary situation: warned his daughter that someone she wrongly believed to be her friend had betrayed her trust and marketed a sex tape featuring her. Catherine Mansky Paulson, who uses the stage name Katie Joy Paulson, has nonetheless spent the ensuing 2 years falsifying, claiming the opposite. I love that. Catherine Mansky Paulson, who uses the stage name Katie Joy Paulson. Drag queen name. Miss Paulson is an internet personality. Oh, he doesn't say she's a journalist, who through her company, WOACB, monetizes her social media presence on YouTube, Twitter, Instagram, and Facebook. Miss Paulson claims to be a close friend of Mr. Chrisley's daughter and frequently touts her relationship with Lindsay Chrisley through her various social media outlets. Because Miss Paulson dedicates so much of her content of her social media accounts to reality television, her relationship with Lindsay Chrisley helps distinguish her from competing internet personalities with similar focus. Hello, Laura. Hello to those who've just stepped in. So we're just looking over Todd Chrisley's claim first, as part of Graham Martin's, her lawyer's affidavit. And then we're going to get to her motion to dismiss. And I will warn you not to drink anything because I nearly had coffee all over my computer earlier today. So, all right. Since Lindsay Chrisley's interview with Dr. Phil, Miss Paulson has frequently repeated the false claim that Mr. Chrisley attempted to extort his daughter by threatening to release a sex tape and naked pictures if she refused to lie to the authorities investigating Mr. Chrisley. She has embroidered this falsehood, claiming and implying that she possessed independent cooperating evidence to bolster it. Miss Paulson's false statements concerning Mr. Chrisley attempting to extort his daughter with a sex tape include the following. Well, you know what's really interesting with Peter? She actually describes in her motion to dismiss. She describes herself as a friend of Lindsay. So, it, could that be deemed a lie now? I don't know. So, Miss Paulson's false statements concerning Mr. Chrisley attempting to extort his daughter with a sex tape include the following. On October 19, 2019, Miss Paulson posted a now deleted YouTube video lasting more than 45 minutes dedicated to the allegation that Mr. Chrisley attempted to extort his daughter with the sex tape. In that video, Miss Paulson speculated at length that Mr. Chrisley was involved in a plot to extort his daughter. Miss Paulson repeated the allegations that Chase Chrisley and possibly Todd were coercing Lindsay and Robbie. The assumption here is that Chase was attempting to obtain any videos, nude photos that he would have of Lindsay in an effort to have leverage over her, in order to threaten her and to cooperate with the investigation. In another, now deleted YouTube video from October 19, 2019, Miss Paulson claimed that somebody anonymously from the Chrisley Knows Best crew actually reached out to me to let me know that they watched Lindsay Chrisley's interview on Dr. Phil, and they say, I believe her. I'm not even lying. Miss Paulson goes on to again repeat that Todd Chrisley approached Lindsay and told her about nude photos and a video that her brother Chase had obtained for $5,000, and that she needed to be careful about what she said or things wouldn't end well, with the implication that the PR team might leak a story with containing those nude photos, or that she was having an affair with a Georgia state official. She then proceeded to describe her interview with the anonymous Chrisley Knows Best crew member, intending to bolster this allegation. On information and belief, there was no interview with an anonymous Chrisley Knows Best crew member, and Miss Paulson fabricated the whole encounter. Her deletion of this video appears to confirm as much. In another YouTube video dated 23 of October 2019, Miss Paulson again repeated at length the allegation that Mr. Chrisley threatened to release the sex tape if Lindsay Chrisley did not cooperate. She further stated that tweets Mr. Chrisley had posted much earlier were clearly threats that he's going to release this tape. On January 5, 2020 YouTube video, Miss Paulson again repeated the allegation that Mr. Chrisley had attempted to extort his daughter with a sex tape. She stated, among other statements, who would want to read stuff from a father that is constantly saying negative things about you? And how threatening to release trying to buy a tape between you and your ex because they are mad at you because you wouldn't lie to federal prosecutors, or federal prosecutors really into investigations into his alleged tax evasion. Oh, Peter watched it live. So everything that's he's saying is true, is it? Similarly, in a series of tweets dated 25th of June 2020, Miss Paulson read again the falsehood that Mr. Chrisley threatened his daughter with releasing a sex tape. Miss Paulson alluded to receiving private details or information from Lindsay Chrisley and stated with regard to the allegation that Mr. Chrisley attempted to extort his daughter with a sex tape, I believe her. In yet another tweet dated August 12, 2021, Miss Paulson falsely claimed that Lindsay Chrisley provided evidence for an alleged sex tape extortion by Todd Chrisley and Chase Chrisley. In reality, Lindsay Chrisley provided no evidence at all indicating that Todd Chrisley had attempted to extort her with a sex tape. On the 13th of August 2021, Miss Paulson created a Facebook post concerning the allegation that Mr. Chrisley attempted to extort his daughter with a sex tape. In that Facebook post, Miss Paulson points to screenshots of an affidavit that made no mention of Mr. Chrisley, but Miss Paulson nonetheless proceeded to imply that Mr. Chrisley was was involved in a plot to extort his daughter by saying, in a text message allegedly between Todd and Lindsay Chrisley, Todd allegedly tells Lindsay that she was worth $5,000 to her friend. He claims to have knowledge of the video. On August 21, 2021, Ms. Paulson made an Instagram post discussing Mr. Chrisley and referring to the allegation that Mr. Chrisley attempted to extort his daughter with a sex tape and naked pictures. She noted that Lindsay Chrisley had posted a screenshot of Todd Chrisley and Lindsay talking about the sex tape and a $5,000 price tag. The screenshot indicates that Lindsay Chrisley did not believe her father to be involved in any effort to extort her by threatening to release the sex tape. Ms. Paulson concludes the post by stating, "Extortion is a felony," referencing to the false claims that Mr. Chrisley attempted to extort his daughter. Ms. Paulson broadcast the sex tape statements to many thousands of people through her various social media outlets. Ms. Paulson knew the sex tape statements to be false when she made them, or at least acted with reckless disregard to the truth. Ms. Paulson knew the sex tape statements to be false based on her relationship and regular communications with Lindsay Chrisley. Moreover, the sex tape statements are so sensationalistic as to be improbable on their face. Any reasonable person would have cause to doubt the claim that a father attempted to extort his own daughter by threatening to release a sex tape and nude photographs involving her. On information and belief, Ms. Paulson also knew that she had not received inside information from an anonymous Chrisley Knows Best crew member or from Lindsay Chrisley herself corroborating the sex tape statements. Indeed, Lindsay Chrisley has testified under oath that certain of Ms. Paulson's claims about receiving information that certain of Ms. Paulson's claims about receiving information from her are false. Ms. Paulson falsely claimed and implied otherwise in order to bolster her own credibility in repeating and elaborating on this malicious lie. The fact that Ms. Paulson invented cooperating evidence further demonstrates Ms. Paulson's knowledge that the sex tape statements were false. Finally, Ms. Paulson removed a number of the most egregious the sex tape statements from her various social media posts. In particular, she removed her video claiming that Chrisley Knows Best crew member had provided an interview corroborating the sex tape statements. This again demonstrates her knowledge that the sex tape statements were false and defamatory. Ms. Paulson made the sex tape statements to strengthen her relationship with Lindsay Chrisley, who is locked in a public feud with her father and whose claimed friendship is an important feature of Ms. Paulson's social media business. Ms. Paulson further made the sex tape statements because of their sensational nature, drew a large crowd to her social media presence. Ms. Paulson monetized this web traffic through her company, WOACB. It's interesting that he said that she monetized it all. Ms. Paulson's broadcast of the sex tape statements to an audience of many thousands has spread and perpetuated the false allegation that Mr. Chrisley attempted to extort his own daughter with the release of the sex tape and nude photos. Not content merely to claim that Mr. Chrisley attempted to extort his own daughter, Ms. Paulson has taken to claiming that Mr. Chrisley attempted to extort her as well. In a series of social media posts, Ms. Paulson falsely stated that in responding to her serial harassment, Mr. Chrisley had acted criminally. The Paulson extortion claims. These claims include the following. On August 6, 2021, Ms. Paulson wrote on Twitter, "Today we served Todd Chrisley's attorney with a cease and desist for defamation, extortion, and tortious interference for threats he's made over the past 3 weeks. It's against the law to threaten to destroy someone unless they provide private information. Extortion is a felony." Do you remember that tweet? The same day, Ms. Paulson wrote a post on Instagram with a screenshot of the above tweet stating, "Extortion is a felony and punishable by prison time. At this time, we have not reported this to the FBI. Threatening someone to hand over private information or else you will ruin them is extortion, and under the law is a criminal felony. We take these threats as seriously as Mr. Chrisley is on bond for federal charges related to 9-count indictment." Miss Paulson broadcast the Paulson extortion claims to many thousands of people through her social media outlets. These allegations of criminality are false. Mr. Chrisley at no point attempted to extort Miss Paulson, and Miss Paulson's accusations are clearly not meant to be rhetorical hyperbole. I know you're all saying it. I know you're all correcting me. Well, I mean, most defamation cases, as we know, are settled. I mean, we were all in Friendly Geordie's corner and he ended up settling. So, you know. Hyperbole. I've got it. Miss Paulson knew the statements to be false, or at least acted with reckless disregard as to their falsity. She again made these statements in an effort to drive web traffic to her various social media accounts for her own financial gain. So count one was defamation per se, this for the sex tapes. Mr. Chrisley incorporates by reference the foregoing paragraphs as if fully set forth herein, and further alleges as follows. Miss Paulson communicated the sex tape statements to many thousands of people through her social media outlets. It's really interesting because she, in her motion to dismiss, she confirms how many people she's got. So she's going to prove his point that she has many thousands. Miss Paulson's allegations that Mr. Chrisley attempted to extort his own daughter with a sex tape and nude photographs, that he attempted to suborn perjury, are categorically false. As explained above, Miss Paulson knew the sex tape statements to be false when she made them, or at the very least acted with reckless disregard for their truth. She thus made these statements with actual malice. Miss Paulson made the sex tape statements to further her own pecuniary interest. She monetized the web traffic these sensational and false claims drove to her various social media platforms through her business WOACB, under the auspices of which she operates for her various social media accounts. The sex tape statements accuse Mr. Chrisley of committing crimes of moral turpitude, extortion, and suborning perjury. They have further harmed Mr. Chrisley in his trade as an entertainer. The sex tape statements therefore constitute defamation per se. The sex tape statements have caused and should continue to cause Mr. Chrisley significant reputational harm, mental distress, humiliation, and embarrassment. So now we've got count 2, defamation. Mr. Chrisley incorporates by reference the foregoing paragraphs as if fully set forth herein, and further alleges as follows. Miss Paulson communicated the sex tape statements to many thousands of people through her various social media outlets. Miss Paulson's allegations that Mr. Chrisley attempted to extort his own daughter with a sex tape and nude photographs, that he attempted to suborn perjury, and categorically false. As explained above, Miss Paulson knew the sex tape statements to be false when she made them, or at the very least acted with reckless disregard for their truth. She made those statements with actual malice. Mrs. Paulson made the sex tape statements to further her own pecuniary interests. She monetized the web traffic. These sensational and false claims drove to her various social media platforms through her business WOACB, under the auspices of which she operates her various social media accounts. The sex tape statements have caused and to continue to cause Mr. Chrisley significant reputational harm, mental distress, humiliation, and embarrassment. So now we've got count 3, defamation per se. This is the Paulson extortion claims. Again, hands up if you saw Katie Joy's social media accounts where she accused Chrisley of extortion. Put your hand up. Because I saw him. Mr. Chrisley incorporates by reference the foregoing paragraphs as if fully set forth herein, and alleges as follows. Miss Paulson communicated the Paulson extortion claims to many thousands of people through her various social media outlets. Miss Paulson's allegations that Mr. Chrisley attempted to extort her and therefore committed a felony punishable by prison time are categorically false. As explained above, Miss Paulson knew the Paulson extortion claims to be false when she made them, or at the very least acted with reckless disregard for their truth. She thus made these statements with actual malice. Miss Paulson made the Paulson extortion claims to further her own pecuniary interests. She monetized web traffic. The web traffic these sensational and false claims drove to her various social media platforms through her business, WOACB, under the auspices of which she operates her various social media accounts. The Paulson extortion claim accused Mr. Chrisley of committing crimes of moral turpitude. You'd rather have a cultural extortion and witness tampering. The Paulson extortion claims therefore constitute defamation per se. Well, actually, we're reading Todd Chrisley's complaint at the moment. We're getting to her motion to dismiss. The Paulson extortion claims have caused and to continue to cause Mr. Chrisley significant reputational harm, mental distress, humiliation, and embarrassment. So count 4? Defamation. Hello, Spanky. Mr. Chrisley incorporates by reference the foregoing paragraphs as if fully set forth herein, and further alleges as follows. Miss Paulson communicated the Paulson extortion claims to many thousands of people through her social media outlets. Miss Paulson communicated with the Paulson extortion claims to... Miss Paulson's allegations that Mr. Chrisley attempted to extort her and therefore committed a felony punishable by prison time are categorically false. As explained above, Miss Paulson knew the Paulson extortion claims to be false when she made them, or at least the very least acted with reckless disregard for their truth. She thus made these statements with actual malice. Miss Paulson made the Paulson extortion claims to further her own pecuniary interests. She monetized the web traffic these sensational and false claims drove to her various social media platforms. I don't know what she said. I paid very little to what she says. Drove her various social media platforms through her business, WOACB, which she operates her social media accounts. The Paulson extortion claims accuse Mr. Chrisley of committing crimes of moral turpitude, extortion, and witness tampering. The Paulson extortion claims therefore constitute defamation per se. So the Paulson extortion claims have caused and continue to cause Mr. Chrisley significant reputational harm, mental distress, humiliation, and embarrassment. So this is what he wants. Oh, cool. I'm glad that you got... I'm glad that you had your induction today. This is her lawyer's affidavit, yeah. That wherefore, Mr. Chrisley prays that judgment be entered in his favour, awarding the following: damages to be proved at trial by which Mr. Chrisley reasonably believes to exceed $50,000, an injunction against Miss Paulson's further publication of the defamatory allegations set forth herein, and whatever further relief the court deems just and equitable. The undersigned acknowledges costs, da-da-da-da-da. And then that was put in by the lawyer. So that was the complaint from Todd Chrisley. So for Exhibit 2, they've pulled up, so Mr. Martin has put up the US District Court, Northern District of Georgia, criminal docket for case. So this is Todd Chrisley, and this is talking about all the charges that he had. So this is where she's talking about the felony. So assigned to the judge, Julie Chrisley. So they've pulled in all the court records. Terminated counts none. They're trying to show that all of this, everything that Chrisley's saying is not true. So there's the United States government, and then they've put in all the dockets. Look, indictment, press-a-pay filed, arrest warrant, appearance bond. All right. Minute entry. So this is essentially the lawyer's defense. This is essentially what they're stating. All right, so we've got this 11th Amendment to General Order. So we're still going. There's 48 pages to this affidavit, David. So that's that one. And then what he's showing here, which is really interesting. So submission of report recommendation as to Todd Chrisley, Julie Chrisley, motion to suppress evidence. So all of that. Yeah, motion to suppress evidence. So they're showing that they did this. Oh, actually, what date did they do it? On the 8th of the 11th. So they're showing that a few days ago they did it, and this is the most recent one. So they're trying to imply that Todd Chrisley is not a nice man. Exhibit 3. This is the Chrisley versus Waits one. This is what the deposition is for, I believe. Defendant versus defendant Joshua Waits. So, and again, see motion to dismiss Joshua Waits. So it's still going. So it's a very long and complicated, by the looks of it. So there was a telephone conference. Document filed in error. Motion to quash. Another document filed in error. Notice by Michael T. Chrisley, notice of intent to serve subpoenas. Intended to serve subpoenas, certificate of service. And then Joshua Waits has filed notice to intention to file subpoenas. Certificate of service for discovery. Notice of depositions. Just seeing if I can see if I can find. So anyway, certificate of service of discovery. So they're up to discovery. So anyway, again, that's essentially. Oh, Exhibit 4. This is the Cherokee County Sheriff's Office. On the 16th of 7th, 19, I was dispatched to contact Lindsay Campbell in reference to threats. And then it says on 16 terroristic threats. Sorry. All right. On July 16, 2019, I was dispatched to contact Lindsay Campbell in reference to threats. Upon speaking to Lindsay, she stated there is an ongoing issue with her family, threatening and harassing her. Lindsay stated she recently learned her stepbrother, who lives out of state, claims to have purchased a sex tape involving Lindsay. Lindsay stated her father and stepbrother wanted to lie about the incident, and if she refused to do so, they were going to release the sex tape involving her. I asked Lindsay if there was, in fact, a sex tape in existence for her to be concerned about, and Lindsay stated it was possible. I explained I would document the incident for her and somebody would follow up with her. I then returned to service. So There you go. So now we get to the document we've been waiting for. All right, you ready? Don't have a drink now. Have something to eat now because I don't want you choking shortly. And don't say you've not been warned. All right. And then I want to know whether you think she wrote it or whether you think a lawyer wrote it. All right. So this is memorandum of law in support of defendant's motion to dismiss. Introduction. It's Michael Todd Chrisley versus Catherine Mansky Paulson and without a crystal ball. You're eating dinner, Rufus? Well, you've been warned. That's all I'm going to say. All right? I'm going to make this bigger so you can read it. I'll try and make this bigger so you can read it. Whoops. All right. Plaintiff, Michael, we'll do it this way. Can we do it? Plaintiff, Michael Todd Chrisley, hereinafter Chrisley, a national television personality, podcast broadcaster, real estate mogul, and celebrity who regularly thrusts himself into the public eye, brings a suit before this court based entirely on speculation and anger. Anger with a daughter whose public articulations of his atrocious behaviour he dislikes, and anger with a member of the press or media that repeats his daughter's statements. Told you I couldn't get past the first paragraph. She's not a member of the press, and she's not a member of the media. That daughter, Lindsay Chrisley, aka Lindsay Chrisley Campbell, has publicly reported that Chrisley threatened to release a sex tape involving her alongside nude photos of her. She discussed this threat on national television. The motion to dismiss is here. This is the motion to dismiss here. Hang on. This is it here. That's the motion to dismiss. I know, right? All right. She discussed this threat on national television and has subsequently discussed with multiple media sources. She even made a police report on the matter, making the story a victim statement. The defendant, Catherine Mansky Paulson, hereinafter Paulson, is a journalist. All right, I got it. The defendant is a journalist focusing on celebrity news and entertainment stories, among myriad other items she has reported on over the last 3 years. Paulson has addressed the statements of her friend, Lindsay Chrisley. Paulson is far from, and it's underlined, far from the only journalist to cover this story. But she is the only journalist Chrisley has sued over her coverage of Lindsay Chrisley's victim statement discussion of the same on national television. The possible reasons for the threat Chrisley issued to his daughter and the potential ramifications to do of the same. All right. So she's a journalist. Due to the lack of substantial statements provided by Chrisley in his complaint, the mere parroting of case law language. I nearly spat I've not actually got any further than this bit. I couldn't get past it. Hi, Keto. I've not read anything past facts. I couldn't get past the fact that she said she's a journalist. Anyway, due to the lack of substantial statements, I should be serious, shouldn't I? Provided by Chrisley in his complaint, the mere parroting of case law language without facts supporting its application, and his complaint's inability to overcome 1. The protections against libel suits afforded to journalists covering public figures. She's not a journalist. And 2, the fact that most of the complaint of behaviour simply consists of statements that are true or opinion. Paulson brings this motion to dismiss plaintiff's complaint. Defendant asserts that complaint should be dismissed for failure to state a claim upon which relief can be granted pursuant to Minnesota R. Civ P 12 as more fully articulated herein. So she's using the protection of journalism. Now, somebody did send me a screenshot earlier. Let me just get that there was a case in, oops, you can see my desktop. Whoops, that was clever, wasn't it? I'm really smart, aren't I? Oh no, I doxed myself. Oh dear me. I'm an idiot, but that's okay. So this was a screenshot that in 2014, blogger Crystal Cox accused of corrupt and fraudulent. Although the court dismissed most of Cox's blog posts as opinion, it found one post to be factual in its assertions, therefore defamation. It was ruled for the first time by the Court of Appeals in the Ninth Court that a blogger is entitled to the same free speech protection as a journalist and cannot be liable for defamation unless the blogger acted negligently. In his decision, journalists and bloggers are equally protected under the First Amendment because the protections of the First Amendment do not turn on whether defendant was a trained journalist, formerly affiliated with traditional news services, engaged in conflict of interest. Disclosure went beyond. So she could get done. She actually could get done for negligence, possibly. But anyway. Look, I know. The thing is, most journalists know when not to cross the line. Okay. So here we go. Plaintiff Michael Todd Chrisley is an individual resident of the state of Tennessee and a national celebrity. For the past 9 years, he's been a central figure of the USA Network reality television show Chrisley Knows Best. See complaint attached to the declaration Graham M. Martin, which has spawned multiple spin-off series. He is also the progenitor of a 160-episode podcast, Chrisley Confessions, which he co-hosts with his wife, Julie. See here. These are all publicly known, objective, and easy verifiable facts about Chrisley's public life, of which the court can take judicial notice. So, do you remember in the Tardy Westbrook thing that they were talking about putting all those hundreds of videos as judicial notice? So it's happened again. She wants support. They are all publicly known, objective, and easily verifiable facts about Chrisley's public life, of which the court can take judicial notice. All right. Defendant Catherine Mansky Paulson is an individual resident of the state of Minnesota and a nationally known entertainment and celebrity journalist. She is regularly cited and reported on herself in national public. Hang on, it says she is regularly cited and reported on herself. Is that saying that she's reported on herself? That she reports on herself? She had to. This makes no sense. She's regularly cited. she is regularly cited and reported on herself in national publications. So she reports on herself, okay. Such as People Magazine, In Touch Weekly, The Today Show, US Weekly, and more. That's why I've read it 3 times, because she's regularly cited and reported on herself in national publications. She has a... So do you think she's written it herself? She has a YouTube channel with over 186,000 subscribers, which is the forum in which she broadcasts most of her reporting. Her videos have generated nearly 88 million views. See, there's her link. They are all publicly known, objective, and readily verifiable facts of which the court can take judicial notice. Well, I'm sure that the court really wants to sit through and watch all of all of the videos. On August 13, 2019, a grand jury indicted Chrisley and his wife on 10 counts of 1. Attempt and conspiracy to commit fraud, 2. Bank fraud, 3. Fraud by wire, radio, or television, 4. Conspiracy to defraud the United States, and 5. And 5. Attempt to evade of defeat tax. And then they put that in there. The case is currently scheduled to go to trial on Monday, May 16, 2022, docket 117. Martin Declaration 3. I think this is tacky too, but the existence of a court proceeding is an objective statement of fact which the court can take judicial notice. In response to the criminal case, Chrisley filed a suit against Joshua Waits, the director of the... All right, so can someone tell me, what does Chrisley's criminal cases have to do with the fact that do with all the stuff that she said about him? Other things: improper dissemination of tax returns and tax return information to Chrisley's daughter, Lindsay Chrisley. Chrisley versus Waits. That case was filed on October 15, 2019. The existence of a court proceeding is an objective statement of fact of which the court can take judicial notice. Oh, I know what it is. It's just you don't. Yeah, it must be the way they do it in Minnesota. The existence of a court proceeding is an objective statement of fact of which the court can take judicial notice. But he has not complained about the fact that she talked about that she about the cases as such. Chrisley admits in his complaint that his daughter, Chrisley admits in his complaint that his daughter, Lindsay Chrisley, gave a nationally televised interview on the talk show Dr. Phil on October 17, 2019, recounting her own experience of being threatened by her father with exposure of a sex tape on which she was featured, as well as nude photos. If she did not provide testimony in the criminal case stating that she had an affair with a state official for the purposes of influencing the investigation of Chrisley. At 16, the interview is still online and freely viewable by the public on the Dr. Phil website. You reckon KJ wrote this? I'm thinking so. In response to the meeting discussed with Dr. Phil, Lindsay Chrisley filed a police report with the Cherokee County Sheriff's Office on July 16, 2019 at 4:20 p.m. Martin Declaration. The police report was reported on nationally by TMZ.com on August 15, 2019, and is a public record of which this court can take judicial notice. The police report addresses terroristic threats and records Lindsay Chrisley's narrative in part as follows. Upon speaking to Lindsay, she stated there is an ongoing issue with her family threatening and harassing her. Lindsay stated that she recently learned her stepbrother, who lives out of state, claimed to have purchased the sex tape involving Lindsay. Lindsay stated her father and stepbrother wanted her to lie about an incident, and if she refused to do so, they were going to release the sex tape involving her. In her career as an entertainment and celebrity journalist, oh no, Paulson has covered the above-mentioned situations a number of times since it first occurred in 2019, as have many other media sources that cover similar material. You are not media. A cursory review of state and federal dockets for the states and districts in which other media sources, such as TMZ.com and People Magazine, US Weekly, and Dr. Phil's parent companies, Petesky Productions Inc. and CPS Interactive Inc., are headquartered, indicate that despite similar coverage to that of Paulson, none of them have been sued by Chrisley for defamation, libel, or other similar torts. I've not seen any of those people imply that to talk about Chrisley's sexuality, for example. Standard overview: pleadings that fail to state a claim upon which relief can be granted must be dismissed. A motion to dismiss tests the legal sufficiency with the complaint. Witzman versus Wrightson case law. When determining a motion to dismiss, the court takes the facts alleged in the complaint as true. On a motion to dismiss for failure to state a claim, the district court may consider only the complaint and the documents referred to in the complaint. And that's been underlined, emphasis added. A complaint states a claim for relief if it fairly gives notice of the claim and is sufficient to permit the application of doctrine of res judicata. This bit was written by the lawyer, of course. However, the court is not bound by legal conclusions stated in a complaint when determining whether the complaint survives a motion to dismiss for failure to state a claim. More case law. Furthermore, in a complaint, a plaintiff must provide more than labels and conclusions. A claim is sufficient against a motion to dismiss for failure to state a claim if it is possible on every evidence which might be produced, consistent with the pleader's theory, again underlined, to grant relief demanded. Whilst it does not require the court to develop additional theories of the case that may constitute a basis for relief outside the plaintiff's theory of the case solely as expressed in the complaint. Finally, important in this matter, due to its involvement of a public figure and public records, on a motion to dismiss, the court may consider, in addition to the pleadings, materials embraced by the pleadings and materials that are part of public record. So, another case, even when addressing a motion to dismiss, the court may take judicial notice of filings of public record and the fact, but not the veracity of parties' assertions therein. On the facts alleged, the plaintiff cannot meet the doubly heightened standard for defamation actions against members of the media by public figures. She's not going there, is she? On plain reading of the typical defamation standard applicable to interactions between two ordinary private individuals, plaintiff's complaint may hold water, if not for the fact that his alleged defamatory statements by the defendant are true, as noted in the 2B set below. However, this case is not one of a simple disagreement between two such private individuals. Rather, the parties consist on one hand of a national celebrity who by his own design has thrust himself into the national spotlight repeatedly, and on the other hand, and on the other of a nationally prominent entertainment journalist to whom protections afforded to the press and media apply. Oh no, I can't. Do I have to keep reading? She's not a journalist. A nationally prominent entertainment journalist to whom protections afforded the press and media apply. She doesn't even have a press pass. You know what? The first thing I'd do if I was Chrisley is I'd be asking for her journalism degree. In this case, the plaintiff cannot merely rely on either the common law formulations of defamation or the Minnesota Supreme Court holdings in the case, because it does not address the application of its principles either to its members of the media or to public figures. The elements of a standard defamation case, a defamation course of action require that A, the statement be false. 2, it was communicated to someone other than the plaintiff. And 3, it tended to harm the plaintiff's reputation and lower him or her in the estimation of the community. While Sturmgesetz is useful in providing guidance on the question of whether a defendant made statements with actual malice, we need to look at other sources for application with defamation standards this matter. And because the sources of law applicable in Minnesota provide an increased burden for a plaintiff, A, alleging defamation by a journalist. She's not a journalist! And B, if the plaintiff is a public figure, Chrisley's complaint cannot meet those standards and must be dismissed. To be actionable, alleged defamatory statements involving a public figure must be made with actual malice, which cannot be shown in this case. Well, exactly. A long history of United States Supreme Court cases provides protections for journalists making negative statements about an individual. In its landmark case, New York Times versus Sullivan, in the United States Supreme Court, UAK Rufus. See, I did warn you. Adopted a new set of constitutional protections for publishers and information relevant to public discourse. Libel can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. Hang on, doesn't she call herself a public figure? So it's really public figure versus public figure, if we want to get technical. The general proposition that freedom of expression upon public questions is secured by the First Amendment has long been settled by our decisions. Authoritative interpretations of the First Amendment guarantees have consistently refused to recognise an exception for any test of truth, whether administered by judges, juries, or administration officials, and especially one that puts the burden of proof on the speaker. Minnesota adopted the holdings and consequences of New York Times in Rose versus Koch, agreeing that the state laws of libel that fail to provide safeguards for freedom of speech of the press guaranteed by the First Amendment to the United States Constitution and made applicable to the states by the 14th Amendment are constitutionally deficient. The Minnesota Supreme Court went on to adopt a number of holdings produced by the New York Times lines of case. We've got a footnote after New York Times, additional lines of cases, and then they added more cases. Just don't drink, Rufus. Don't drive, Rufus. All right. So first, public officials and other public figures are subject to vigorous attack, including, under certain circumstances, defamatory, untruthful attack. Second, the privilege of defamatory attack is applicable to public figures, even though such figures are not public officials. Third, the meaning of actual malice stated in New York Times, although not fully articulated in subsequent decisions of the United States Supreme Court, has been given definition, at least in terms of what it is not. What the New York Times rule ultimately protects is defamatory falsehood. And now this is bolded. No matter how gross the untruth, the New York Times rule deprives a defamed public figure of any hope for legal redress without proof that it was a lie, that the lie was a knowing one or uttered in reckless disregard of the truth. In addition to Minnesota's adoption of the New York Times line of cases, reporting on statements made by law enforcement is specifically protected for journalists in Minnesota via the fair report privilege. She's not a journalist. Stating the fair report privilege applies to fair and accurate reports of statements by law enforcement. And the fair report privilege protected fair and accurate news report about a press conference and news release. The Larson Court highlighted the Monero Court's reliance on the restatement, second of torts, at section 611, which states the publication of defamatory matter concerning another in a report of an official action or proceeding or of a meeting open to the public that deals with a matter of public concern is privileged against claims of defamation if the report is accurate, complete, or a fair abridgment of the occurrence reported. Similarly, the Minnesota Court of Appeals stated in Jadwin versus Minneapolis that newspapers have a qualified privilege when making a fair and accurate report of public records. But she's not a newspaper. While there may be some disagreement as to the application of this privilege to the Dr. Phil interview, the police report is certainly a public record, affording the application of the fair reporting privilege to report on. Paulson's recitations of the complaint of material are drawn almost wholly from the police report and televised interview Lindsay Chrisley sat for with Dr. Phil. The fact Paulson repeats those items does not change their privilege, nor does it change the fact that they were statements made by eyewitnesses whose accounts have presumptive veracity. Well, I guess now that makes me a journalist, eh? Oh. Regardless of the light in which those statements paint Chrisley, and regardless of whether he agrees with those statements, they are privileged against claims of defamation and are therefore improper basis for causes of action listed in his complaint. Chrisley is a public figure. Oh, well, yeah. You're a journalist. Oh, and, the Oprah thing. You're a journalist, and you're a journalist. We're all journalists! Sorry to the real journalists out there. Chrisley is a public figure subjecting his defamation claims to a different standard. As to whether public figures may take action against journalists, or anyone for that matter, reporting on or publishing information about their investigations into the public figure's activities, the Constitution delimits a state's power to award damages for liable in actions brought by public officials against critics of their official conduct. As noted in rows above, public figures are subject to vigorous attacks, and they must show actual malice. Which is not what it sounds like. Rather, for a public figure to recover on a claim of defamation, he carries the burden of proving that the alleged lie was a knowing one or uttered in reckless disregard to the truth. In the case of Gertz versus Robert Welsh, the United States Supreme Court articulated 3 classes of people for purposes of analysing defamation libel claims. In full, that statement follows, hypothetically, it may be possible for someone to become a public figure through no purposeful action of his own, but the instances of truly involuntary public figures must be exceedingly rare. For the most part, those who obtain this status have assumed roles of a special prominence in the affairs of society. Some occupy positions such as persuasive power and influence that they are deemed public figures for all purposes. More commonly, those classified as public figures have thrust themselves to the forefront of particular public controversies in order to influence the resolution of these issues involved. In either event, they invite attention and comment. In my opinion, she's whatever works for her at the time. Because she wasn't a journalist when it came to the Tardy Westbrook case, and now suddenly she's a journalist. The Minnesota Supreme Court also adopted this breakdown, summarising it in the following manner. And she refers to herself as a blogger. So, the first group indicates the rare involuntary public figure. The next category essentially contains celebrities and prominent social figures who are deemed public figures for all purposes. The final group consists of a limited purpose public figures who attain their position by thrusting themselves into the vortex of a public controversy to influence its outcome. Regardless of whether we use the Gertz or Jadwin formulations to guide us in this case currently before the court, the outcome is the same. Chrisley is no mere private individual. As made clear by Chrisley in his own complaint and by additional verifiable objective information regarding Chrisley, available through a simple Google search, the plaintiff in the case before this court is without a doubt a public figure. He has thrust himself into the media spotlight through the production of multiple national television shows, the foremost of which has been running for 9 seasons on the USA Network. a podcast with over 150 episodes, and continued and vocal call-outs to people across the country with whom he has a bone to pick. He and his media appearances are regularly covered by People magazine. She's put links here: Life and Style magazine, Parade magazine, and countless other news sources throughout the world. He has also a verifiable legion of followers, just about as many times as journalist. He has a verifiable legion of followers to whom he caters, with nearly 379,000 Twitter followers and over 2.3 million followers on Instagram. A review of 33 stories and 18 videos referencing Chrisley on TMZ.com shows time and again a man who forces his way into the spotlight regardless of its effects on him. If that were not enough, he began pursuing civil suits against state officials in Georgia and his suit against Paulson in response to the criminal proceedings in which he is currently engaged. He regularly produces angry, threatening, or provocative statements publicly, knowing that they'll be read and reposted by hundreds of thousands of people. Whether for all purposes or only with respect to issues he raises as basis for his defamation claims, Chrisley is obviously a public figure, and a public figure, Chrisley cannot rely solely on the standard of articulation of defamation provided by Stummenbergs. Rather, Chrisley must meet a higher standard of proof and prove the statements were made with actual malice. Well, you just listen to the tone of her voice. That is, with the knowledge that it was false or with reckless disregard of whether it was false or not. Just the tone of her voice would tell you that it was with reckless disregard, in my opinion. To recover against a defendant, a public figure must meet an elevated burden of proof and show not only the statements were false, but also that the defendant acted with actual malice, which the plaintiff cannot show. Actual malice for defamation purposes have been interpreted to mean the defendant acted with a reckless disregard for the truth or had a high degree of knowledge of the statement's probably falsity. Well, yes, Patheos did remove all of our articles. Again, more case law. Motives of diminishing plaintiff's credibility do not establish actual malice. When there was no evidence the media had actual knowledge of falsity, she's not the media, in my opinion. A determined effort to conform to a previous form suspicion does not establish malice. Furthermore, the United States Supreme Court notes the term actual malice is unfortunately confusing in that it has nothing to do with bad motive or ill will. What happened? Regarding similar intentional international torts regarding similar intentional torts damaging a person, the United States Supreme Court has held that a public figure may not recover for the tort of intentional infliction of emotional distress without showing that the publication contains a false statement of fact, which was made with knowledge that the statement was false or with reckless disregard as to whether it was true or not. So the statement she made about his sexuality, that was definitely a false statement. The court goes on, nor can the fact that the defendant published the defamatory material in order to increase its profits suffice to prove actual malice. Although the concept of reckless disregard cannot be fully encompassed in one infallible definition, we have made clear that the defendant must have made false publication with a high degree of awareness, probable falsity, and have entertained serious doubts as to the truth of the publication. Despite his knowledge of his fame and celebrity, and despite his participation in stories and acts that form the basis for his allegations regarding the defamation by Paulson, he has failed to include one single piece of evidence proving the alleged defamatory statements are known lies or that they were uttered in reckless disregard of the truth. He did talk about the fact that some of the stuff was deleted. But anyway, Chrisley provided the precise opposite of the necessary proof, acknowledging that his daughter Lindsay gave an eyewitness account and a police report on which Paulson's reporting was based, and that she told and retold the story with consistency to multiple parties. Oh, hang on, that was Chrisley, not Katie Joy. We're back. We must be back to her writing again because now it's confusing. Describing the story Lindsay Chrisley told in her interview with Dr. Phil and acknowledging the personal relationship between Lindsay and Paulson. But didn't Lindsay say that there was no relationship? The only proof rebutting Lindsay's story and Paulson's reporting thereon comes in the form of a single baseless allegation uttered repeatedly throughout the complaint in different forms. Lindsay Chrisley's account of the meeting is inaccurate. The remainder of Chrisley's complaint restates ad nauseum asserted legal conclusions that somehow Paulson's reporting on Lindsay Chrisley's national televised interview and matching content in the police report constitutes defamation. But aside from Chrisley's attack on Paulson's sources being anonymous, there is nothing of substance providing a single actionable allegation under the standards of the New York Times lines of cases and Minnesota's adoption therein of Rose. Instead, Chrisley relies on a series of assertions that provide no proof and no basis for meeting his burden to show actual malice, as defined in the case law. For example, Chrisley relies on speculation on the basis of his allegations in the following paragraphs. 23b, on information and belief. 26, claiming to know Paulson's mind without any evidence to support it. We all know Paulson's mind because she talks ad nauseum. 27, oops, did I say that out loud? On information and belief without any evidence. 29 to 30, claiming to know Paulson's mind without any evidence to support it. And 36, claiming to know Paulson's motivations without any evidence to support it. But I thought he could put in the evidence at a later date. It was just to get the thing through court. These unsupported statements are repeated time and time again through Chrisley's causes of action as well, each time without support. Similarly, Chrisley complains repeatedly of Paulson's reporting on Lindsay Chrisley's victim statement, whether it was given in the Dr. Phil interview or the police report, without any explanation or allegation supporting the proposition that reporting on a witness's own statement is the basis for defamation sufficient to overcome the burden required by public figures making defamation claims or the fair reporting privilege. Can I just say, she's opened a can of worms, because if she's going to complain about anybody reading her police reports, for example, they're just going to use the fair reporting privilege, aren't they? In paragraphs 23A, 23C to F, 31, and multiple repetitions thereof throughout his courses of action, Chrisley continues to harp on Paulson for merely reporting on eyewitness statements made by Lindsay Chrisley, but again, simply reporting on information provided by a witness, whether anonymous or confidential, is not. If the information is confidential, why are you blurring it out? But again, simply reporting on information provided by a witness, whether anonymous and confidential or not, is not sufficient to undergird a cause of action for defamation against a public figure, particularly in the light of fair reporting privilege. Thank you, Rufus, which applies to statements Paulson made that relate to police report. Finally, Paulson's own statements about her interaction with Chrisley cannot be actionable under the New York Times lines of cases and Rose, because they have a stronger defense that they are true statements, however disparaging, are not actionable. So today we serve Todd Chrisley's attorney with a cease and desist for defamation. It's against the law to threaten to destroy someone unless they provide information. Extortion is a felony. While some of these statements may not be artful, hello, Villanova. Thanks for your link. Okay, cool. Well, some of these statements may not be artful. They are certainly more or less reflections of reality. What a weird sentence. Similarly, each of the discrete sentences in paragraph 33b is either true or an opinion statement. In any event, they cannot support a defamation claim under any theory of defamation available in Minnesota. In short, Chrisley's complaint is so devoid. This is Katie Joy. In short, Chrisley's complaint is so devoid of substantive allegations that it barely meets the standards for the run-of-the-mill defamation action as articulated in Stumbages, even on the most favourable reading of the complaint's allegations. Chrisley provides no basis for either A, overcoming constitutional protections for the press. Again, she's not the press. Or 2, meeting his burden of proof, showing the existence of actual malice required for public figures. For the foregoing reasons, defendants respectively request that the court grant their motion to dismiss for failure to state a claim on which relief may be granted and dismiss all the plaintiff's claims with prejudice. I thought it would be without prejudice. No, with prejudice. Okay. And then the party on whose behalf the attached document is served acknowledges through the undersigned counsel that sanctions, including reasonable attorney fees and other expenses, may be awarded to the opposite parties. So there you go. So he's done it on her behalf. So what are your thoughts, people? I'm still getting over the fact that she's using the journalist defense. Well, thank you, Rufus. That's yeah. She's using the journalism defense, eh? But I'm a journalist. So what? Yeah. So thoughts? She's a good journalist. I know Michael West. Has just been given another cease and desist, hasn't he? I mean, if you look at somebody, if you look at, one of Louise Milligan, I think her name's. She's an ABC journalist. She's had a couple of defamation claims, but she actually made some. But hers were against politicians because her stuff was the stuff that she had was pretty damning, and there was evidence for it. So, as I said, I think it's a very interesting defense. I'll be very interesting to see what Emily D. Baker thinks of it. I'd like to hear what Rikita Law thinks of it too, because he is in Minnesota, so he would understand how the law works. I'd be interested to see his take on it, because he would know, being a lawyer in that area. Well, technically, hello, Sky. Yes, she's actually technically, or she should be an internationally recognised. Yes, so KJ is essentially asking the court to throw it out because she's using journalistic fair reporting as her defence. She could probably make one. No, she doesn't have a press pass, but she was going to make one. That's right. She's publicly stated that she's not. She's publicly stated she's not a journalist. How many times has she said she's not a journalist? And as Peter pointed out in the Westbrook case, she said she was a YouTuber. So she's not a journalist. So, yes, and apparently she's been cited in all these trash magazines. It'd be like me saying I'm a journalist because I've been on Sky News. I haven't, but that Sky News had picked up something that I had said. I wouldn't want to. I did see her post on Instagram, some of it anyway. I won't be talking much longer because it was that was a big talk fest, and I need to get ready for work, and so yeah, I'll just have a look at her Instagram. But I wanted just to get the document. I just wanted to put the document out there because she did tell us it was all public record. And she did tell us, and she wanted us to go and have a look at it. And well, yes, I am an actor because I was on that. Yes, that's right. Oh dear. Oh dear me. Oh dear me. Oh no. Apparently, tell me when did Dirty Dancing come out? Can someone please help me with that? Wasn't that in the 90s? Or was that the late 80s? Oh yes, and my feet. Yes, my feet still get me a commission. I get $10 a year for commission. You reckon 87? So this is her Instagram. On this day, a queen was born. Happy birthday to me. Because she talked about how her. Oh, thank you, Lady Crane. Because she talks about how somebody about how something about baby. What was it? What was it on here? A queen, yeah. I don't. Oh yeah. The one mantra I lived with as a kid was no one puts baby in a corner. And that's why I'm saying I thought that came out when I was 1980. I was 12 or 13 when that came out. So that's not like kid like, that's teenager. Correct. And then she's put Footloose. What's Footloose doing there? So then she says, as a child, I knew exactly what I wanted to do with my life. I wanted to tell stories from as young as I can remember. I've always wanted to be a writer, journalist, and someone that shared stories with others. After years of corporate America, I gave up my job to become a stay-at-home mum and pursue my dream. It's wild to me that I could turn a dream into a reality, but I'm forever grateful. I am grateful to all the other storytellers who inspired me along the way. So here she's saying, has Lindsay Chrisley said it too? But here she's saying that she's a storyteller. Look, I am grateful to all the other storytellers. So she's saying she's a storyteller. So she's not a journalist at all. And quite often, yeah. So there we go. Anyway, thank you for bearing through that. That was long and tough. And although there was a bit of laughter because, as I said, apparently now we found out she's a journalist. And she's using journalistic privilege. Sky. Well, that's the story she gives, isn't it? She talks about how yes. Yeah. All right. I will catch you later. I may not stream tomorrow because I finish one job and then I've got to go to another job, and I may have a little sleep. So it depends on how much sleep I get. Otherwise, I'll see you Saturday for sure. Saturday night for sure. I'm off to work. All right, cool. I don't know if I should broadcast this. I'm off to work on your assignment. That's all right. It's a part that's not that part's the part that Rufus is doing is not assessed. Yeah, make sure you hit like before you leave. Hit subscribe as well. Whatever. And as I said, I'll catch you later. Thank you for all the laughs. And have a good day, night, whatever. And we'll keep seeing what happens with this. I'm sure Todd Chrisley's got something to say about it all.